students. Do we, as individuals with disabilities, always want identical treatment? No. Right? I want time and a half on my exam. I want a ramp to the front door. Right? I want a bathroom I can use. Right? So that's not identical treatment. Because like language minority children, there's something fundamentally different about these individuals. Well, where did we come up with this notion of reasonable accommodation? Some people think we got it from some religious discrimination statutes because they use the same word. But the answer is no. Because I was there, and I worked with the people, and I've talked to the people that worked on those regulations. The notion that we had the authority to define discrimination to require an affirmative duty to accommodate came from Lau v. Nichols. Okay? But the story does not end there. Because the Department of Education Office for Civil Rights, now feeling its oats from Lau v. Nichols, has subsequently issued many what's called Dear Colleague letters. So the May 25th memorandum was called a memorandum. Now they call them Dear Colleague letters. It's the same damn thing. Okay? So now, after 9/11, there was a problem of discrimination against Muslims and a discrimination against Jews. There was a lot of conflict. Do we have authority under Title VI to reach religious discrimination? And the plain answer is no. Except if you twist the words around national origin discrimination carefully enough, you may actually be able to protect Muslims and Jews. And so we issued a Dear Colleague letter saying just that. If you look at Title IX of the Civil Rights Act, you know that we don't have direct authority to address sexual orientation discrimination. Okay? But if you file a sexual orientation discrimination with OCR, there's a Dear Colleague letter that may help you because it prohibits discrimination on the basis of sexual stereotyping. So if a young man is bullied because he's effeminate at school, we've got jurisdiction. And I foresee that OCR, as time goes on, will see new and different issues to address. And only because of the experience in Lao will we have a path to addressing these different issues as they may arise. So I have seen a huge political change because of Lao that goes way beyond the classroom. Not that the classroom isn't critically important, but also a huge change coming out of Lao that addresses each form of discrimination as our society must address that emerging form. So thank you all for working on Lao because it's had such a huge and broad impact.
I want to start and thank Professor Long for inviting me here, and Henry Durr, our former executive director, Christina Wong, our program director. I feel like there are big shoes to fill at CAA doing this work, and I've been at CAA for 4 years, and I didn't realize how deeply I would be working on language access as our legacy issue. So I want to talk a little bit how we have responded to the changing ways in which language access is understood for the ability of limited English proficient residents to be able to access public services. So it is a shift from Lao and from that original framework situated in civil rights work. And I also want to quickly just acknowledge my colleague Betty Cow is in the audience, and she is our parent organizer, and she is doing the wonderful work of working with our parent leaders, following the processes that Christina has really helped to implement at the school district. And so Betty, day in and day out, is training our limited English proficient Chinese parents. They have children in the school district, and she trains them on the Lao Action Plan. She trains them about the school structure, and so she is really in charge of the empowerment of our parent leaders to then be able to advocate for their children because of Lao. So I just want to give a little shout out to Betty in the audience. So now I'll talk about, I think it was Dean Moran who mentioned that within the broader context of language access and immigrant integration, we're seeing this trend of local progressivism, and I really think that the San Francisco Language Access Ordinance is a great example of that. I should say that it is still more of an experiment. I don't know how successful we have been, but at CAA in 2001, we were involved with the passage of the Equal Access to Services Ordinance. And so this was passed at the City and County of San Francisco. And this was really in response to a lack of enforcement with the state language access law. So at the California state level, the Timely Allotory Bilingual Services Act was not being enforced. There was audit after audit that showed that the State Personnel Board, they were not informing state agencies of what their requirements are. 80% of state agencies were completely unaware of the requirements to have bilingual staff or to have vital documents translated. So San Francisco, as a local municipality, really wanted to respond. And so CAA was heavily involved in the drafting of that ordinance in 2001. In 2009, it was amended and strengthened to be what is now the Language Access Ordinance. And I will say that I often see national language access reports or other cities such as Washington, D.C. or Seattle, and they have a little blurb and they say San Francisco has the strongest language access ordinance. But I just laugh at that because the implementation has been a problem. And so I'll just share a little bit about what the ordinance is, what our struggles have been in terms of seeing the full realization of that ordinance, and how we have tried to respond creatively. So first, I'll just run through what the ordinance does is it requires that there be a publicly posted sign in city agencies. So that sign has to be in language. It has to advise people of their right to request interpretation. So the ordinance also says anyone has the right to request interpretation. It doesn't matter if you speak a small minority language, anybody has that right. I should say that the ordinance does not say that then the agency has to provide interpretation, but it says that everyone has the right to request it. It says that vital documents need to be provided in translation in language for certain languages that meet a threshold. And so these would be vital documents that have to do with perhaps your eligibility for a public benefit or a complaint form. And these are really, these are impacting city agencies that play crucial roles in public service. So the police department, the fire department, public housing, emergency planning, and so a whole host of organizations and agencies have to comply. They also have to have bilingual employees, these employees have to be placed at the front desk, really the positions that are interacting with the public. So with this ordinance being, quote, the strongest language access ordinance in the nation, we've seen a lot of problems. This is very different from Lao. There is no affirmative duty to accommodate. There's no private right to action. There's no penalties. So it's fairly unenforceable aside from the community being very creative in how we can publicly shame agencies. So what we're seeing is that to see the full realization of this ordinance, it would require tremendous cultural change that's really, getting at the hearts and minds of people in terms of whether or not they even want to embrace and welcome immigrants or non-English speakers. We have explored the option of looking at, do we amend the ordinance further, but what we've really seen is that this is an issue of resources and training and technical assistance in the implementation. So the biggest issues that we have seen is that there is a lack of documentation. Each year, a city agency fills out a scorecard. It's all self-reported. They give themselves A+ across the board. So you can imagine if you walk into any office in Chinatown or the Mission, we would laugh at that. We know based on the walk-in clients that we have coming to our offices that there are violations happening every single day. Again, this is also an issue of resources. I think it has been very easy for the city of San Francisco to say, well, language access is important, but it's expensive, it's going to cost money. So fortunately, in 2012, CAA saw an opportunity in the budget advocacy process. The city and county of San Francisco had a surplus. This is just a few years coming out of the recession. And if any of you are familiar with the budget process at the city, I think of it as when you go to feed fish and you're dropping in the food and everybody and all the fish, they float to the top and they try to get their bite of it. So that's what it is. There's budget analysis and the community finds out how much money is there in the surplus. And then the interests start coming out and people start lobbying the Board of Supervisors. So we were aware that there was going to be a surplus, and it was quite a large surplus that would be divvied out through this budget add-back process. And we really felt like this was our opportunity. We had to move language access. This was another opportunity like this wasn't going to happen. And if we were going to come out, let's come out swinging, and let's say that language access has to happen now. It's time that we move it forward. So we had done some simple analysis about the resources and how budgets had been spent for language access. And we had to have that catchy one-liner. And so our one-liner that we put on Facebook, we put it on Twitter, we sent it in emails to the supervisors, and we said 44% of San Francisco residents speak a language other than English at home, and less than 0.1% of the city budget is spent on language services. And that had traction, and so we were able to really garner support from other community members. I called many of our allies that we work with in the community, and it was so obvious to them, but I think because language access is so integrated into our work daily that they didn't step aside and think, how can we change this? We need to do something. So we were really able to mobilize a lot of community support. I should say that it was surprising how some supervisors were very resentful that we were coming to them with this issue. I think they felt like it's always going to be a back burner issue, and we were successful. We just didn't let up. We really did come out swinging. We asked for a $2 million allocation for language services. I think we got $250,000. So we're still trying to chip away and really reach the full amount that we think we need to see at the city level to be able to see some tangible changes. One effort that has come out of that funding allocation is we were inspired by community efforts in Washington, D.C. that we really felt the documentation process of how language access is happening is very problematic, and we wanted to provide for an independent, community-based